I'm beginning the meeting. Welcome to meeting number 25 of the Standing Committee on Industry and Technology, pursuant to Standing Order 1082 and the motion adopted by the committee on Friday, May 13th, 2022. The committee is meeting to study the subject matter of Part 5, Divisions 15, 16, and 17 of Bill C-19, Budget Implementation Act 2022, Number 1. Today's meeting place is taking place in a hybrid format pursuant to the House Order of November 25th, 2021. Members are attending in person in the room and remotely using the Zoom application. If you have the chance to be here in Ottawa, you know that there are sanitary measures still in place. I'm pleased to be able to introduce your witnesses, but before I begin, let me just apologize and thank our witnesses for their patience. There was a vote that delayed the beginning of this meeting, but we need to stop at exactly 3 p.m., so thank you for your collaboration. We have with us as an individual Vas Bednar, back as Executive Director of Master of Public Policy and Digital Society Program at McMaster University. Hello, Mr. Bednar. Dr. Jennifer Quaid as well, Associate Professor and Vice Dean Research, Civil Law Section at the Faculty of Law, University of Ottawa, is here in Ottawa with us. We also have William Wu, a partner in competition, antitrust, and foreign investment at Macmillan Law Firm. From the C.D. Howe Institute, we have Benjamin Datchis, Associate Vice President of Public Affairs. From the Canadian Bar Association, we have Eliza Kearney, Second Vice Chair, Competition Law and Foreign Investment Review Section, as well as Dominique Terrien, who is Secretary in the same section. And from Unifor, we have Kaylee Thiessen, National Representative from the Research Department. Thank you very much to all of you for being here, and I'll ask Ms. Bednar to begin. You have 5 minutes.
Thank you, and hello again. In addition to my leadership role at McMaster University, I'm one of the country's most vocal advocates for competition reform. I've contributed in modest but meaningful ways to the policy attention to these questions through opinion editorials in the Globe and Mail, the National Post, research published by McGill University, commissioned by ISED, various podcast interviews, and my newsletter, Regs to Riches. And I think I'm back here to discuss the BIA with you because people are squirming. I don't mean the people, I mean corporate interests that have long benefited from the policy inertia on competition. The usual suspects have lost their monopoly on this conversation, which has meant that decision makers like you are asking really important questions, like how we can promote more dynamic and fair markets. This is a good thing. It's good because an Ipsos poll from earlier this year illuminated that most, 88% of Canadians, say that we need more competition and that it's too easy for big business to take advantage of them as consumers. And to me, this kind of last-minute, short notice INDU meeting on a Friday before a long weekend feels kind of like it's a perfect example of just that. Big business moving to skew a policy process that should be a no-brainer. The initial amendments to the Competition Act that are currently contained in the BIA are a crucial down payment on competition reform. And in this way, they are, unfortunately, they're also a bit of a test. They're a test of whether Canada takes competition reform seriously. And for way too long, we quite simply have not. If you look at the available data, prices tend to go up after mergers, despite what companies claim before the merger occurs. Now, the Washington Center for Equitable Growth, it recently put together a searchable database of about 150 economic papers. A lot of these papers show empirical evidence that the permissive approach of authorities in the US has led to higher prices and less competition. Comparable Canadian research just doesn't exist. But there's so much that Canada should be learning from other jurisdictions, and this extends beyond policy ideas and implementation inspiration to a caution about the insane amount of lobbying dollars that are spent, usually by the largest technology firms, to stall antitrust policy change. A popular company tactic is the whitewashing of their perspectives through otherwise reputable think tanks and academics, or even the creation of shell organizations that are designed to resemble authentic grassroots interventions, like Meta's American Edge or Amazon and Google's Connected Commerce Council. So back to the question of whether these initial amendments require further study, or if they should be retained. Well, the challenge of wage fixing has already been deeply explored through the good work of this committee. A range of stakeholders are in agreement that it must be addressed. Do we need to study whether the proposed AMPs are just too strong a punishment or a deterrent? Well, there's a whole body of literature that looks at the deterrent effects of fines in competition law, and it supports what's in the BIA. Do we need to debate whether drip pricing has any utility for consumers that get tricked about what the actual retail price is for something by this deceptive marketing tactic? These proposed changes are the absolute lowest hanging fruit. We shouldn't be examining them further at this point because they clearly serve the public interest at a time where Canadians are under intense economic pressure. They'll improve the enforcement of the Act. They were clearly foreshadowed in a February press release from the minister. They're aligned with analysis from the Competition Bureau, and they've been discussed at length in the public domain, including at this very committee. Let's keep these encouraging, overdue amendments in the BIA. You must signal to Canadians that leaders in Ottawa will actually protect them and create the conditions for innovation and entrepreneurship. So should they be studied further? Yes, we can study their implementation. We can debate the mechanics of that implementation. And we should support more research into the dynamics of competition in Canada because we obviously need it. But we don't need any more backroom baseball or tapping the brakes on reform. Now, you've heard from some respondents that having amendments contained in the budget bill is anti-democratic. And budget omnibus bills are imperfect democratic tools, yes, but there is an opportunity to better protect Canadians as they face the rising cost of living today. Can we have more discussion about the nuances of these changes? Yes, and we will. But should we drop them altogether right now? No way. It is impossible to justify the status quo on competition in Canada, and yet it persists. The stakeholders that are agitating behind the scenes can go on the record with their concerns when the government launches a broad, open, inclusive, and independent consultation on competition later this year. Such a consultation has been foreshadowed and endorsed by the godfathers of competition in Canada, people like Senator Howard Weston, Lawson Hunter, and others. And at that time, those private actors that oppose these promising amendments, these early changes, this down payment, they can step forward instead of hiding behind their lawyers or lobbying behind the scenes. They can go on the record with their rationale for why we don't need these changes and convince Canadians. They can convince Canadians that there are instances where wage fixing while the cost of living for Canadians rises is perfectly acceptable. They can come and convince Canadians that the AMPs proportional to the size of an offender are just too strong a deterrent. They can come and explain to Canadians why it's okay to hide the real price from people when they're shopping online. That is democracy, and that is what we need to improve Canada's competition laws. Thank you.
Thank you very much, Madame Bernard. I'll now move to Professor Quaid for 5 minutes.
Chair, honorable committee members, I'm delighted to appear before you today. Last week, we had a very good discussion about the proposed modifications to the Competition Act, amendments rather to the Competition Act in Part 5, Section 15 of the Budget Implementation Act 2022 as part of your study on small and medium-sized businesses. I welcome the opportunity to discuss the amendments in a broader context today, and I want you to note also that the panel of witnesses you've convened is impressive. You will have undoubtedly have the benefit of some very enlightening and thought-provoking comments from all of them. My name is Jennifer Quaid. I'm Associate Professor and Vice Dean of Research in the Civil Law section at the University of Ottawa. My areas of expertise are primarily at the intersection of criminal law and business law, corporate criminal law, competition law, anti-corruption and white-collar crime, business laws, and general criminal law.
Week in which I lamented the use of a budget bill to enact substantive changes to the Competition Act. My views have not changed on this. Using a BIA as a fast track for amendments, however well-intentioned, is a practice that has gotten out of hand. It undermines the legitimacy of the provisions that are enacted in this way because there is no time for debate on the merits, even where there is agreement. And there's no opportunity for scrutiny and constructive comments to ensure the provisions work as intended. I alluded to it last week. I won't go into detail now because we're late and short of time. But an example is the enactment of Part 22.1 of the Criminal Code, which was enacted in haste, a substantive change to the criminal law, and we are reaping what we sow because we saw arguments in court last week which suggest that, contrary to the intentions, there were arguments made that were completely different. So I think we need to be careful about rushed amendments. However, I want to be practical today. The focus of my remarks today will be on how to move forward in the less than optimal conditions we find ourselves. And I've taken to heart some advice that was provided to me by a colleague when I was writing my doctoral dissertation, which is beware, the good is the better is the enemy of the good. So Je repasserai en
I will review the content of the proposed changes in order to highlight what's good, even if it would have been better with the benefit of more consultation time. Of course, I share with you my thoughts formed during an intensive period. We've really worked hard in the last few weeks, so my ideas may evolve over the coming weeks and months. Of the 8 proposed amendments, there is only one that is not good, and I'll insist on that. It's the provision that proposes to add a wage fixing offense, Section 45 1.1 of the Code. We discussed this last week, and I have a lot to say on it. It's a lot to do with not only the principle, but the process, the wording in the Act. There are many problems, and I think it deserves much more study. As for the rest, I think that the amendments, even if they're not perfect, they could be adopted without leading to catastrophe.
In almost all these cases, the amendments, though they are imperfect, could be made, let's say, complemented by advice from the Bureau and publication of enforcement guidelines. And I really hope that that is forthcoming quickly, because some of these changes will need support. I'm going to go very quickly and provide sort of one line on every amendment, but of course I'm happy to discuss in detail later. On the increase of the fine to Section 45 to a fine in the discretion of the court, this brings the fine of 45 in line with the other serious provisions in the Act, 46, 47, and 52. But I caution this committee that there is a serious escalation of the penalties for the criminal provisions of the Act, and I think that merits consideration in round 2. So it looks elegant and symmetrical, but it's hiding a bigger problem. The next thing is the changes to the AMPs, and there's been a lot of debate about that. My friends at the CBA will have a lot more to say about that. Let's say that I think we need to focus on the key thing here, which is that the maximum, the additions are in relation to cases where we go above the maximum. And I think that frames a little bit our concerns to really focus on the cases where we would be above those maxima. So we're not talking about SMEs, we're not talking about small businesses, we're talking about larger businesses. We're talking about the Facebooks of this world. So I think we need to put that into context. I acknowledge there are some things we can debate, like the metrics. In terms of drip pricing, yes, it's a specific provision. Yes, there are some things that could have been better done. But at the end of the day, the Bureau already enforces against drip pricing. This is just being more specific. So I think that we can leave room for modification or tinkering. I think there is some stuff that will need to be looked at. But I also think Bureau enforcement advice might help get us through the period before we can modify the provision to our satisfaction. There are new factors that have been added to the abusive dominance, merger, and civil collaboration regimes in terms of referring to elements of the digital economy, consumer privacy, sort of the referring indirectly to nascent competitors and so forth. The language is a little more precise than I'm making it right now. I don't think there's really any problem with that. The Bureau is probably already taking into account those provisions through the basket clauses that are provided in each of those sections, and all we're doing is being more transparent about it. So again, is this the last word? I doubt it. In fact, I think at the consultation, we're probably going to have a substantial discussion about whether we need to restructure some of these analytical frameworks. But in the short term, I don't think that this is a big deal. Other countries are also taking account these factors. I'm going to be going super fast. In terms of the private right of action, I hear my friends who are concerned that this could be used as a way, perhaps, for unsatisfied competitors to maybe not entirely meritoriously target dominant firms. I'm not sure I share their concerns, and I would be interested to know what kind of evidence suggests that that is really a problem. My greater concern is that a private right of action cannot be viewed as something that diminishes the role of the commissioner, because the commissioner still has an important role here. So this is not a savings in enforcement, it's a complement. On the modifications to the abusive dominant position, I think that these were proposed actually by Professor Iacobucci, who's very cautious about modifying the Act, but he thinks there's a gap, and I tend to agree with him. So again, not perfect. Maybe we're going to restructure abusive dominance completely differently after the consultation, but for now, I'm not sure this is going to create a huge problem in the short term. Cases on abuse of dominance take time to bring together and to analyze. On the general anti-avoidance, and the revisions to Section 11, these were both requests by the Commissioner, and I think that we need to keep in mind that, I can't substitute my judgment for what they think is necessary. Maybe this committee can ask them for further details and examples to give a dimension to the problem. Is there an anti-avoidance problem? But I can't comment really factually about whether this is an overreach or whether this is going to be a problem. I'm sure my friends from the CBA will have more to say on that. I just want to conclude, and I know I'm over time, to say this is step one. I'm trying to be practical to give you suggestions for how to get to step two, which is the really important game. We need this consultation. We need the substantive analysis. Je ne peux pas souligner assez.
I cannot emphasize this strongly enough that this consultation needs to take place and it needs to be as broad as possible. We must update our competition policy and law, but it should be done by fleshing out the major values that we want to associate with it. We especially need a strong law when it comes to the digital field, but the law can only be reformed through this essential consultation step. And I'll stop there and await your questions. Thank you very much. I'll ask Mr. William Wu to speak now.
Thank you very much for this opportunity to appear before this committee. My name is William Wu. I'm a partner in the Competition and Foreign Investment Group at Macmillan in Toronto. It has been almost 15 years since the last major review of Canadian competition law and competition policy. So I think everybody here would agree that it is time for another review of Canadian competition law. And in this regard, I applaud Minister Champagne's an announcement for a broad review of Competition Act. And that consultation would need to be broad and inclusive, and I think everybody here would agree with that. And with that in mind, it is unclear to me why is it that we need to have all these amendments done through this process right now, when the broader consultation is coming, I believe, in the next couple of months. And in relation to the wage fixing and no poaching provision in particular, in the bill itself, it's intended to that provision is intended to only come into force 1 year after the BIA receives royal assent. So it already contemplates that there is something more that needs to be done to that provision. So with that delay already built in, and I see really no compelling reason why that provision in particular needs to be rushed through this regulatory process right now. And in terms of the substance of the no poaching and wage fixing provision, I share Professor Quaid's concern that using criminal law to deal with this issue may not be appropriate. And looking at wage fixing and no poaching agreement, I think we really can conceive it as a competition law issue or as a labor and employment law issue. To the extent that it is a competition law issue, the concern would be that employers are agreeing not to compete in their hiring or compensation practices. And if that's a concern, I would say using criminal law to create a per se prohibition is too blunt an instrument. There are a lot of legitimate and pro-competitive reasons why employers might want to talk to each other about their hiring and compensation practices, and I can speak to those in more detail later. And it is not obvious at all that this type of agreement will always cause harm to employees by depriving them of higher wages or job opportunities. So in that context, given that there can be harmful no poaching and wage fixing agreements, and there can be legitimate ones as well, using the existing civil reviewable practices provision in Section 90.1 of the Act, I would say that is an appropriate competition law framework to address these issues. Now, to the extent that the concern is the protection of workers, in particular low-wage workers, That's traditionally within the ambit of provincial labor and employment law and less of a competition law issue. So I would submit that labor and employment law and labor and employment law regulators are better equipped and they have better expertise and experience in dealing with those issues. And I will actually probably stop here for now, given the short time today, and happy to answer questions. I do have other views on other amendments, particularly the drip pricing provision, but I can speak to those during questions.
Thank you very much, Mr. Wu. I'll now move to Mr. Dashi.
Great, thank you very much. And I have the great pleasure of working with the C.D. Howe Institute's Competition Policy Council, which is comprised of top-ranked competition law academics and practitioners. Lisa Kearney, who you'll be hearing from later today in her role with the CPA, is the chair of the council. Now, the core concern of the council is the scope of changes to the Competition Act in the BAA are not fulfilling the commitment articulated in Budget 2022 to consult broadly on the role and functioning of the Competition Act and its enforcement regime. So let me address some problems that could have been fixed with consultation on the specifics in the bill. First, the changes proposed in the BAA result in corporations now facing administrative monetary penalties, or AMPs, of up to 3% of annual worldwide gross revenues. Now, the legal details really matter here. If an AMP is penal in nature rather than a deterrent, then it is effectively a criminal penalty, and the alleged offender must be tried in accordance with due process requirements of Section 11 of the Charter of Rights and Freedoms. Neither the misleading advertising nor the abuse of dominance provisions that attract these significant penalties are criminal offenses, and the burden of proof to be convicted is a lower balance of probability standard. Now, the increase to the fines to be set on global revenues of a firm that, and this is a critical part, are not directly related to the harms of the practice, greatly raises the likelihood that the fines could be found as penal and therefore unconstitutional.
Monsieur le Président, ça fait 2 fois en français que l'interprète mentionne qu'il y a des problèmes.
The interpreter has said twice now in French that there are problems with the sound. Chair.
Should I start again? No,
Okay, so it seems to be a network issue, but if you can speak a little slower, Mr. Sure. Dashi. Yeah.
Will do. Can you hear me okay now?
Is it better? Yeah. Okay, it's better. Okay. Yeah, thanks.
Sorry about that. Now, with such large potential penalties, there's a risk of over-deterrence, and firms may shy away from practices that may be beneficial for Canadians. These potential fines raise reputational risks for Canada as not being supportive of foreign investment, given that fines will be disproportionately large for foreign multinationals. The risks of over-deterrence are magnified by the changes in the BAA to allow private parties access to the tribunal to make a complaint about abuse of dominance. Although private litigants do not have the ability to receive damages themselves, the defendants in a privately brought case of abuse of dominance will face a large potential fine that will be paid to the government. And this goes well beyond the appropriate role, and there is an appropriate role for private litigation in abuse of dominance, and risks creating private sheriffs where competitor-driven complaints before the tribunal may result in governments levying disproportionate fines against parties. Now, moving to wage fixing and no-poach agreements, there are very sound legal and economic reasons to address them. Price fixing and wage fixing are economically similar. However, as we've heard a couple times before today, the language of the new amendments is overly broad and creates great uncertainty. There's uncertainty about whether the term employee captures all categories of workers. There's no definition of employer and employee in the Competition Act. Now, given the changing nature of employment, as well as the varying provincial definitions of employee-employer relationships, the proposed amendments would benefit from proper consultation with employment law experts directly from the government, rather than what a single committee like this or a single senator like Senator Howard Wetson can manage on their own. Now, I can get to various approaches on how to deal with wage fixing in questions, but William Wu is a real expert on this, so I defer to him in particular. Lastly, on substance, the identification of privacy as a specific characteristic of non-price competition, separate from product quality, raises particular questions. If privacy is distinct from product quality, what does this really mean? Will competition law cases, mergers, for example, turn on a privacy issue, even if competition issues are otherwise unproblematic? Once again, the amendment would have benefited from broader consultation. So let me close on the core problem, and that's process. The problems to the BA are reminiscent of similar process concerns that accompanied the legislative changes to the Competition Act in 2009 via the budget process. Some of the proposed amendments in the BIA now reflect legislative fixes to fix that flawed process. Yet by following the same flawed process, the inevitable result is an overcorrection. The need for legislative amendments again in the future, and more importantly, do not achieve the government's objective of improving the operation of the Competition Act. So what's the practical bottom line? Carving Division 15 out of the BIA would be the right approach. But if that isn't feasible, the committee should call for setting the proclamation date for all provisions, not just some, for a year from passage. We also need to hear more from the government on their plans for further consultation, as they promised. These proposed changes can be seen in concert with other proposed changes that would come as part of a prompt second stage of Competition Act reviews. Now, proceeding right to these amendments taking force, especially ones that may be unconstitutional, without further consultation could be potentially reckless. Now, we can work out details of implementation of changes before they take act with a later proclamation. I'll leave my opening remarks there and look forward to your questions. Thank you again for the invitation to speak on this issue.
Thank you very much, Mr. Dakis, and apologies for mispronouncing your name a couple of times earlier. We'll now turn to the Canadian Bar Association with Madame Kearney and Maître Terrier.
Good afternoon, Mr. Chair and honorable members of the committee. My name is Elisa Kearney. I am the second vice chair with the Competition Law and Foreign Investment Review section of the Canadian Bar Association. Thank you for inviting the CBA to discuss the proposed changes to the Competition Act as set out in the Budget Implementation Act. With me today is Mr. Dominique Thierrien, the secretary of the section.
Merci, Lisa.
Thank you, Lisa. The CBA is a national association of more than 36,000 jurists from across the country. The main goals of the CBA are to improve law and the administration of justice, and it's in this perspective that we are here today on behalf of the Competition Law and Foreign Investment section. Back to you.
To begin, the CBA strongly believes that the proposed amendments to the Competition Act should not be in the BIA. Given the critical role of the Competition Act in promoting dynamic and fair markets, and of the importance of innovation, meaningful and thorough consultations are necessary to ensure that the underlying policy objectives of the proposed amendments are indeed achieved. The CBA does support the government in its ongoing review of the Competition Act, but believes that the amendments proposed in the BIA need to be further amended, studied, and refined to ensure they improve the operation of the Act and do not create unintended adverse consequences. Let me provide a few examples. On abuse of dominance, we are concerned that the proposed substantive amendments on abuse may be overbroad and carry the unintended consequence of softening competition on the merits. These concerns are augmented by the amendments in the BIA that permit private parties to seek relief. The CBA is concerned that competitors will use the threats of private litigation and large penalty awards to deter conduct by rivals that may be pro-competitive and beneficial to Canadians. On the penalties, the BIA proposes to increase the amount of administrative monetary penalties for both deceptive marketing and abuse of dominance to 3 times the value of the benefit derived, or, if that benefit cannot reasonably be determined, 3% of annual worldwide gross revenues. In the view of the CBA, there is no policy for considering benefits arising or sales made outside of Canada when determining an appropriate penalty. The CBA believes that any attempt to connect an AMP to the benefit derived or the overall revenue received should be limited to benefits and revenues in Canada. As you have heard, there are potential constitutional issues with large punitive amounts for non-criminal conduct, and we have concerns that punitive amounts will damage Canada's reputation as a good place for foreign firms to do business with negative effects on the Canadian economy. My colleague, Monsieur Terrien, has a few more examples.
So you've heard before, but I'd like to address now the wage fixing and the no-poach proposed amendments. And the BIA would expand the current per se illegal criminal conspiracy offense under Section 45 to such no-poach and wage fixing agreements. The CBA is of the view that the criminal offense for wage fixing and no-poach agreements may not be the most efficient way to improve the Act's operation. Currently, there's already a non-criminal enforcement track for wage fixing and no-poach agreements that is under Section 90.1 of the Act, but this section has never been used. This provision can be improved to be more effective without resorting to criminal liability, which of course has a higher burden of proof and is thus more difficult to prosecute. And currently, as drafted, we have concerns that the proposed amendments are both over and under inclusive. So first, looking at the proposed wage fixing offense, basically the offense would apply to agreements regarding any term and condition of employment. So any term of condition of employment is without a doubt very broad language and ambiguous to say the least. I also want to echo earlier comments, if we turn now to the proposed no-poach agreement offense, that this would only currently applies to employees, which is an undefined term. And I share the view that under the current changing nature of employment relationships in the Canadian economy, we should further consider that the provision is actually warranted to ensure that it actually captures the government policy objectives. We also want to bring to the committee's attention that an offense under Section 45 basically triggers significant collateral consequences. First of all, we're talking about class actions risk and also debarment risk or losing qualification, being disqualified for public contracts. These issues have not been discussed and should be fully debated before amendments that would bring no-poach and wage-fixing agreements under the criminal offense under Section 45 are rushed through the BIA process. En conclusion, nous sommes heureux de...
In conclusion, we look forward to answering your questions, and we look forward to sharing our concerns with you. Thank you very much. I'll ask Ms. Thiessen from Unifor to speak.
Good afternoon, everyone. My name is Kaylee Thiessen. I'm an economist and a policy analyst in the research department at Unifor. I'm here to discuss the long-awaited initial changes to Canada's competition policy that are inside the budget implementation bill. This is the third time in just under 2 years that Unifor has appeared before this committee to discuss Canada's wage-fixing problem. The first was in 2020 when our president, along with 2 local union leaders in the grocery store sector, appeared to ask this committee to investigate the blatant wage fixing that occurred in the sector when the major grocery stores all canceled pandemic pay on the same day. The second was in the spring of 2021 when I appeared here to discuss our recommendations for strengthening the Competition Act. We want to improve outcomes for workers and consumers in Canada through a Competition Act that actually accomplishes creating the conditions for healthy competition in this country. So I'm here before you for the third time to remind you of 4 things. 1, making wage fixing and no poach agreements a criminal offense is the bare minimum that must be done to foster fair competition in Canada and the labor markets. 2, wage fixing and no poach agreements used to be considered criminal offenses in the Competition Act. 3, 2 egregious cases of anti-competitive behavior in labor markets have recently been rejected by competition investigators. This is in the last 18 months because of the high threshold required by civil law, not because any competition officer thought that the actions were not anti-competitive. And then 4, administrative monetary penalties are supposed to be high enough to deter the behavior instead of low enough to become a cost of doing business. So I'll address each of these in more detail individually. So first, doing the bare minimum. Moving wage fixing and no poach agreements back to the realm of a criminal offense is just one of several changes that are needed in order to improve outcomes for workers and consumers through the elimination of anti-competitive behavior. As it currently stands, the Competition Act doesn't specifically consider the effects of anti-competitive behavior on workers at all. The Bureau can pursue anti-competitive behaviors that impact workers through its merger reviews, potentially through other civil provisions, like Section 90.1. We've heard about that already today. This deals with competitor collaborations. However, to date, we find no evidence that the Bureau has actually done a serious investigation. Some of that is actually because that threshold is too high and they would have liked to pursue that, but they couldn't. That means that Canada might be allowing actions that artificially suppress wages and working conditions, decreasing the well-being of workers across the economy. And we don't even have the tools to find out if that's happening. Recent research from the Department of the Treasury found that anti-competitive behaviors in American labor markets has depressed wages by 20%. 20%. And that would 20%. So they're 20% lower than would have been the case if no anti-competitive behavior existed. Number two, wage fixing and no poach agreements used to be criminal offenses under the Competition Act. It wasn't until a change in 2009 that these actions were relegated to the realm of civil law, where the law has languished and remained ineffective at dealing with anti-competitive behavior that I've just mentioned. We're a laggard when it comes to workers' rights under competition law, and the opportunity to change that is right here in front of you today. My third reminder, there are two recent cases that were rejected by competition officers because of this high evidentiary threshold in civil law. The first was the grocery company same-day pandemic pay cancellation that I mentioned earlier, and we've spoken on multiple occasions about that here already. And the second was a class action lawsuit accusing Tim Hortons franchises in BC of artificially lowering wages and working conditions of workers in the industry through no poach agreements. Both of those cases have been rejected under competition law in the last 18 months because of this high threshold of evidence required, not because any competition official thought the actions weren't anti-competitive. And number four, administrative penalties are at risk of becoming a cost of doing business. This is a situation that the Competition Bureau has stated it wants to avoid. And it's my opinion that administrative penalties must be high enough to deter the behavior the law is trying to prohibit, not so low that companies can just absorb that cost and absorb the cost of breaking the law. I have more recommendations to make to the Competition Act review that's coming later this year, and I look forward to coming back here to talk to this committee about them all. Canada's workers are directly and indirectly affected by Canada's competition policy every day. In my experience, the Bureau lacks the power it needs to ensure anti-competitive behavior does not negatively affect wages or working conditions in Canada. Thank you, and I look forward to taking your questions.
Thank you very much to all of our witnesses. Before we open up the discussion, I just want to inform colleagues that given the delays, we'll only have time for the two first rounds of questions. So we'll start without further ado with Monsieur Deltel pour 6 minutes.
Mr. Deltel, you have 6 minutes. Thank you, Chair. Thank you, witnesses, for being here. This is a very interesting and very educational meeting, as usual, even if our time has been cut short for so much. First of all, I'd like to say hello to Mr. Therrien from the Canadian Bar Association. I will concentrate my remarks on you, and I will speak in French. I'd like to know more about the impact on Canadians' reputation abroad. If we quickly amend this bill, that is. What are the concerns that you have with regard to this impact on our international reputation? Thank you for the question. I think that the comment on Canada's reputation or the potential impact is linked to the question of the calculation of administrative monetary policies if ever there's an abuse of dominance as proposed in the amendment. The calculation, and I believe that Professor Quaid said this, we need to go through the steps of the calculation, but it's very difficult to calculate the benefit that a company would derive from problematic behavior. And this amount can be as much as 3% of the business's revenues. However, it's not limited to revenues from Canadian activities. The problem here is that we have a calculation. Well, some people believe it shouldn't be increased at any rate. It's already 10 million. but with a new cap calculated on world revenues, well, that's problematic. Our position is that we need to at least discuss this issue to better target businesses and what we're aiming for with this 3%. Otherwise, Canada's reputation could indeed be harmed if this percentage is taken on world revenues. Question. Most witnesses talked about the administrative monetary policies. If it's illegal, of course, if it's illegal activity, then it's illegal. Someone would have to pay. But do you think that the current law, do you think that if the administrative monetary penalties were too high, that in fact they would not have a deterring effect on businesses? Answer. I think that our section and the Canadian Bar Association's point of view is a combination, is that we want a combination. Caps need to come with a specific framework. This would be in the case of abuse of dominance or misleading advertising. We don't think there's the same provision for fraudulent advertising in other countries. There has to be other criteria taken into account, the impact, how long this misleading advertising goes on for, and so on. There's also, and there could be an investigation to prevent, for the creation of a cap. You have to be careful, though, of class action lawsuits. We've never seen this possibility here in Canada where companies themselves would be able to lodge a complaint. The major AMPs would not go to the companies that make the complaint. It would go to the Canadian government. This is something in the regime that's completely new. We've never seen it before in Canada. We don't understand where it would go. What would happen with such a provision? This could lead to strategic litigation. And then there's also the new caps for civilian. You're saying this is the first time this would take place in Canada? If you look at the CBA's letter, we have a note at the bottom of the page. There was a similar issue in Ontario on the value of real estate, but the max in that case was $1 million. And we think that it has actually never been used. Before we introduce the idea of having private sheriffs, I think this whole concept should be debated. Could there be strategic litigations? And after a private lawsuit, the money would go to Canada? Is this what we want to enable companies to do? This needs to be discussed. Chair, I'm having trouble with my internet connection, but I will continue with Mr. Therrien. The impact on privacy. You and other witnesses said that there would be an impact on privacy. And currently, privacy is a very sensitive issue because of social media. How do you see the privacy being infringed upon with these provisions? I think that we would need to add a criterion to see if anti-competition. I don't want to go too far in my response to this question because the CBA does not yet have a strong position on this matter, but I'll just point out that there is an issue and ask that you pose the question to other witnesses. That's all the time you have, Mr. Deltel. Thank you, Mr. Therrien. Mr. Erskine-Smith, you have 6 minutes.
Thanks very much. Mr. Dacus, I think you said price fixing and wage fixing are economically similar. Why would the Act treat them differently?
So a good example here is the question of competitors. So right now, the legislation as it currently is in force, requires that price fixing be among competitors. And so that is per se illegal. The legislation as proposed includes any agreement among any employers, not necessarily competitors. So this can have much wider ranging application than the way it is.
Why would it ever happen? So can you provide an example where employers in vastly different sectors that aren't competing with one another would enter into an arrangement to fix wages?
For sure. I can give you a no poach agreement, for example. I'll take an example of a consulting company sending someone in-house to a client for a set term for say 3, 4, 5 months, while that employee of the consulting firm is embedded in that client. So rather than that individual person having to just float around on individual contracts, that person can be employed by that consulting company and go from client to client to client. But in order for that company, that consulting company, to want to enter into that agreement, they're going to have to have certainty that they're just not going to lose that employee to that company. So that kind of thing, that kind of arrangement can be beneficial for all parties, where these employees are able to know that they're not going to have to go contract to contract to contract.
Let's talk about but let's not talk about you're talking about no poach. Let's talk about fixing wages. So in the case of what we saw with let's take an example of where there's clear and the evidence around price fixing is such that 45 could be pursued beyond a reasonable doubt. And in a similar matter, wages, say of low-income workers in an oligopoly sector, have been suppressed. And by way of an agreement as between those employers, you don't think that should be treated the same way as price fixing is treated under the Act?
Well, it goes to the definition of per se, and this is where I'll definitely defer to some of the lawyers on this, where they'll certainly be able.
Well, let's go. So let's go then to Mr. Terrian. You mentioned some concerns, and you said the civil standard. There's a civil standard. We can improve upon the civil standard. My understanding, and this is from public comment of former Commissioner Peckman in relation to wage fixing in particular, he said there's just a gap in the legislation. And then in response to a letter that I'd sent Commissioner Boswell, he'd written that it is not proving a substantial lessening or prevention of competition is not a low threshold. And 90.1 is not specific to wages, of course. It's buy-side agreements in general. Don't you think there should be something specific to wages, as there was previously, as there is in other jurisdictions? Should we not be treating wages specifically and separately?
Let me maybe answer twofold. So first of all, like in the past, we had like this general prohibition, criminal prohibition that could encompass any agreements that had an undue lessening of competition. We moved away from that. That was the 2009 amendments. It was further to a very long process, if I may. There were 3 expert reports commended by at the time commissioner to get ideas of what exactly should be per se, with 14 years of prison jail term attached to that. And where we were saying, let's compare to the US. US has been acting against no poach, no non-solicitation since 2010 under civil actions. 2016, they provided guidelines for HR professionals saying next time that's going to be criminal. They've came up with their first criminal, I think, charges in 2020, and something that this committee wasn't aware of, which is just recent. And in our letter, the first trials in the U.S. for criminal no poach and wage fixing, they've lost. So all we're saying is that it would be.
That's not a consequence of a poor approach necessarily. That could well be a consequence of, in those particular instances, they couldn't prove the burden beyond a reasonable doubt. And look, I'm not suggesting that the criminal standard is the right one here. I'm just a bit confused why we're articulating the need to address this problem. I think wage fixing, and I know Mr. Wu had suggested we should treat no poach in particular. I think Mr. Dacus suggested something similar, treat no poach via an employment labor context. But the example that was before this committee previously, specifically around wage fixing, specifically around suppressing low-income employees' wages and communication as between employers in the same sector, in an oligopoly sector on this specific instance, I don't really understand how low-income minimum wages are different from bread.
so maybe I'll just jump in with one comment. I disagree with the commissioner's concern that the need to prove substantial lessening and prevention competition is a burden that he ought not need to discharge. In the specific context of the grocery hero pay situation, that was a very unique situation in the labor market. That was a situation where basically every store other than grocery chains were closed. So in that specific context, one can imagine that type of agreement, that type of wage fixing agreement indeed had an anti-competitive effect on the labor market, because those workers would have nowhere else to turn to for another job opportunity, or they would not have the opportunity to get another job with higher wages elsewhere. But in a hot labor market such as it is right now, with extremely low unemployment rate, the kind of an agreement between some employers to even fix wages, that I would suggest would have limited impact on employees' actual welfare, because kind of especially for employees with kind of generally transferable employment skills, those skills can be easily transferred to another position, and the employer doesn't, the alternative employer doesn't need to be in the same industry. Like, so let's say a grocery worker probably would be using very similar skill sets as someone in another retail context. So when we're thinking about competitors in the kind of no poaching or wage fixing context, the competitor is about who are competing for the same type of employment skills, rather than competitors in the kind of in the supply market.
I'm out of time, but it seems to me 90.1 is insufficient. If you don't like the new proposed 45, it would be very helpful for you to send something to the committee by way of what it should look like, because I want to address this issue. And if the criminal law is not the way to do it, 90.1 isn't sufficient, I don't think. And so it would be helpful, all of you smart people who work in this space and think in this space, send me what you think it ought to be, because the current law, there's a gap in the current law. And if you don't like the current proposal, I'd like to see what the alternative is.
Thank you very much, Mr. Erskine-Smith. We'll move to Monsieur Lemire.
Mr. Lemieux, you have 6 minutes. Thank you, Mr. Thank you, Mr. Speaker. The INDU committee, with regard to technology and Big Com, has examined this question, and we've also looked at it with regard to labor shortage. Several witnesses have told us that there has been a significant reduction in competition. We can think of Ms. Bednar's or Ms. Quaid's testimonials or testimonies, or Mr. Wu's. We also heard from Ms. Chabin and Ms. Larkin. I think that I'd like us to see us take these testimonies into account when we send our report to the Finance Committee. These analyses should be part of our recommendations. INDU in 2021 heard from a small group on the COVID bonuses. We saw how there was an impact on the sale of food. The commissioner from the Competition Bureau, that is, Mr. Boswell, said that he would not pursue the matter because wage fixing is not currently seen as a criminal activity. However, price fixing is a criminal activity. So my question for Ms. Thiessen is, do you think that amendments to the bill, or to the act rather, will dissuade employers from using anti-competition actions?
Let's see. I think that we've seen this committee study this issue. We saw the commissioner and their response and their reasoning behind not studying the issue. We know we have a wage fixing problem. recently or previously when we were here, our president stated, if this is something that's so obvious and these retail giants think they can get away with it, then what else is happening that we don't see and we don't know about and we can't investigate? And we're seeing that it's being thought of as a cost of doing business, or that it's at risk of a cost of doing business, either because they can get away with it, it's not illegal and the threshold is too high, or because the penalties are too high. And so we need to make sure that we are dealing with that issue. This committee made the recommendation last year in your report in June 2021 to make this change to the Competition Act. And I think it's really important that we go forward with it.
My next question will be for Professor Quaid. We understand that the first step to modernizing the Competition Act should be in this Budget Implementation Act. We heard testimonies from experts, competition experts, who said that the Competition Act in Canada is not in line with what's happening elsewhere in the world. Minister Champagne said that these provisions have been proposed because of what's happening with the major digital companies. Do you believe that these amendments are enough? Answer: I'll try to be as brief as possible. This is why I made a different opening statement than the other day. I think that if we leave aside the wage fixing issue, which I think deserves to have an entire session to itself, and I would be delighted to comment in detail on it. If I put aside the other provisions, the fact that I don't think they should be included in a Budget Implementation Act, these are amendments that aren't surprising, that are justifiable, and that allow us to catch up, to attempt to catch up. My viewpoint is perhaps different from my colleagues in that I'm not sure that we'll be criticized or that our reputation will suffer. When we signed an agreement with Facebook, we imposed a $9.5 million fine. The U.S. fined Facebook $5 billion. So I think that we could indeed increase the amount of AMPs. Should we go as high as the Americans and the Europeans as well? No, that was just an example. But I think that gradually, and this is what I've been thinking about this week, that this would be an intermediate step. I don't think it should be an intermediate step that becomes a permanent one, however. But if we can't increase the fines considerably right now, and we want to send out a signal to the market, to citizens, to Canadians, and to businesses and our international partners, I think that these small steps are a good first step. However, with the following reservation, the Competition Bureau needs to quickly publish a statement on how it intends to implement these provisions. I don't think there's a need to suspend the application of the provisions. And I'm excluding wage fixing from this discussion. But it's very important that the Competition Bureau responds to this need for a framework that structures the changes. And let me just say that any amendments to the law would not be a magic bullet. They're not going to change the implementation culture. That's why we need some sort of structure from the Commission that ensures oversight of the bill implementation. The Bureau's excellent at consulting, reacting to what experts say, for example, my colleagues online. But I think it would be an error to think that simply by passing this bill, everything will be solved. With the right conditions, however, with these conditions, I can see that we need to move quickly. Thank you, Professor. Thank you, Mr. Lemire. I'll now ask Mr. Massey to speak for 6 minutes. Mr. Massey has the floor.
And apologies for being a little bit late to the meeting. Had to do a panel show. With regards to the following statement with regards to the AMPS not being similar to the United States, Ms. Quaid, and Europe, what was the kind of the reasoning behind that? So AMPS don't have to; they won't be set at the maximum and be an automatic. Those are up to what it can go to. So what's the detraction for us having some consistency there, especially when we actually have quite a bit of integration on products manufacturing with the United States and other types of standards. But when it comes to consumers and consumer protection, we're particularly poor. I'll give the auto example just as a background, is that we don't get the same afforded protections as U.S. consumers. You look at the Toyota Prius example, emissions from Volkswagens, all kinds of different things where Americans enjoy way greater consumer protection, and yet companies treat Canada as a colony. And I just want to wonder, like, why not at least have that in our back pocket to have the AMPS being significant in case we need to protect consumers?
Well, you missed my opening remarks, but I've become practical, and so look. The AMPS change is a change. I'm not going to pretend it's not a change. I do think on the whole it's a good change. I understand the concerns of my friends at the Canadian Bar Association and in private practice that there is an uncertainty now where there wasn't an uncertainty before. But I think we need to remember a couple of things. The first is that these extra calculations are for amounts that exceed the current maxima. And there will be circumstances where we do not need to exceed the current maxima. In fact, what I would like to see is scalable penalties across the board rather than, saying under 9 million, because that's a huge amount for SMEs. I think I said that last week. But I think we have to keep in mind that for some enterprises, scalable penalties is really the only way you're going to be able to come up with the correct amount. And Canadian courts do not have a good track record at, picking a number out of the air and making it high enough. So I think that tying it to a metric is important. And yes, there's going to be a transition period, but I don't see the downside in allowing penalties to go up. Do we have to reach the levels of the US and Europe? Not necessarily. I would highlight two things. We have a list of aggravating and mitigating factors that must be taken into account when you determine the amount. Those are relevant. This is not a random, arbitrary amount, contrary to what the impression you might be left with. The other thing I would underscore is that for misleading advertising, it's not the case for abuse of dominance. AMPS are only available if the defendant has not been able to establish that they were diligent. So you're already in a zone where you could say the conduct is less justifiable. So I don't know if there's anything else you need, but I'm going to stop there.
No, that helps. I'll allow. I see Mr. Dacus wants to get in, I believe, and anybody else who wants to answer that. I am curious about that. And to be fair, I just want to point as well. Your criticism of this being part of the budget bill is a fair one. It was Paul Martin that brought in the first non-budgetary legislative changes with immigration and a few other things back in 2006, I think. And so since then, we officially, unfortunately, have budget bills that have these elements in them, and it's become kind of similar to the American system. So anybody else wish to comment on the AMPS and where we sit?
I'm on that. So Senator Whetstone's commentary on all the submissions to this process is a really useful touchstone of asking where are the boundaries of debate. And one of the things that was very clear in his commentary was a request to increase AMPS. And there was a consensus on that. There was no consensus, though, on the amount. And so we're spending a lot of our time focused on the 3% of global revenues, rightly so. But there is a provision in there that says that that would allow scalable AMPS for 3 times the value of the benefit derived from the anti-competitive practice. That's the sort of thing that does make some sense in the spirit of Senator Whetstone's consensus statement. Going beyond that, though, is where things get a little bit more problematic.
Okay, thank you. Ms. Bednar, do you feel that the Competition Bureau is structured well enough right now to be able to handle any of the changes that are taking place? Just curious as to what needs to be done there if there is more strengthening.
Oh, thanks for the question. I mean, I think the recent budget increases to the Bureau were welcome. I think that they have some great policy advice that they've gone on the record with. This is a really phenomenal artifact that the Bureau responded to Senator Weston. And if I can just sort of comment and contextualize our Bureau in an international context, since for the purposes of this discussion, our reputation abroad has seemed to factor prominently. In an international stage, we don't register on competition, right? Canada's reputation on competition reform is nothing short of absolutely humiliating. It's captured very well in a recent G7 compendium. No one's looking at us because we aren't doing anything. So again, these are necessary first steps, and I don't have doubts that the Bureau would be able to receive them as we look ahead to further reform.
Thank you. And I'll go back to the original testimony later on. Thank you, Mr. Chair.
Merci beaucoup, Monsieur Massey.
Thank you, Mr. Massey. Mr. Cram, you have 5 minutes.
Thank you very much, Mr. Chair, and thank you to all the witnesses for being here this afternoon. Mr. Dacus, in your opening statement, you used the word unconstitutional. Could you elaborate on why you feel this bill may be unconstitutional?
Yeah, so this goes again to the question that we're talking about in terms of penalties, and the question of it being a penalty versus a deterrent. And when a fine is so large as to be well beyond any potential benefit that the company directly received from the activity, we're starting to get into a different level of penalty. And the Constitution gives a greater level of protection, a higher level of burden of proof that companies are going to be able to receive. So this goes to the drafting of the amendments here, where if there had been a line drawn earlier on with an increase in penalties, but not to that level, along the lines of what the CBA has talked about, where we're talking about things that are connected to Canadian revenues, not just international revenues that are by nature not connected, by definition, not connected to the harm in Canada. There might have been a solution here, but we're looking at some serious risk of unconstitutional changes here that are going to throw the whole enforcement regime in the future into great uncertainty. So I don't want the Canadian Competition Act enforcement regime to be thrown into that uncertainty because of poorly drafted legislation.
So it is Section 11 of the Charter that deals with proceedings in criminal and penal matters. So are you saying that the bill may be in violation of Section 11 of the Charter?
Yes.
Okay. Where else do I have? So you also mentioned that we have a couple of options. One would be to carve out Division 15 from this bill, and the other option would be having a later proclamation date. Do you have a preference between those two recommendations?
So I totally get where the government, why the government would be hesitant to carve out Division 15. Time is the most valuable commodity in the House of Commons, and adding one more bill into a legislative schedule is going to be really tricky, and it creates congestion elsewhere. So I totally get that even though that would be the best approach, that would be something they'd be hesitant to do. Delaying proclamation has a couple of benefits. The first benefit is it gives us more chance to rather than drop tools on on everything when we have other obligations to go in and provide submissions on the details before things have implementation. It allows us the time to properly digest changes. It also helps create a bit of a deadline for a review, the second round of review. We've heard no details from the government in terms of what that review is going to look at. So if they have a timeline of a year from now, we can look at these amendments and what else we might need to have in order to properly digest how all these reforms that a lot of people in the competition world, the economics world, are looking for, how they all fit together and a compromise that we can all work with.
Okay, thank you very much. I'd like to turn now to our two witnesses from the Canadian Bar Association. Your organization sent the committee a letter a couple of days ago, and I would like to read you a quick quote from the letter. Under administrative monetary penalties, it says, "The apparent lack of national treatment afforded to foreign companies may be inconsistent with Canada's obligations under international trade agreements. So I was wondering if you could elaborate which international trade agreements do you feel Canada may be violating, and could you elaborate as to why?
I can take that one. We don't have specifics on under which specific international trade agreement we think there may be a specific concern, but the issue is one of treating foreign companies the same as you treat your Canadian companies, and to the extent that the provision does treat foreign companies who would, we are presuming, have a larger worldwide revenue, then they would be subject to AMPs for potentially even less harmful conduct in Canada at a higher degree. So there are assumptions built into the statement. Of course, there are Canadian companies with significant worldwide revenue that could equally be in the same situation. But I think the point is if you have a fine that's twigged to worldwide revenues for harm that's conducted in Canada, there is a possibility that foreign companies will be subject to higher penalties and thus treated differently than their Canadian counterparts.
Thank you very much. We'll now move to Madame Lapointe for 5 minutes.
Merci, Monsieur le Président.
Ms. Lapointe, you have 5 minutes.
Bednar, and I'd like to build on the questions that were raised by my colleague, MP Erskine Smith. And I'll invite you, Ms. Bednar, if you have some thoughts or if you'd like to elaborate on the exchange that took place between Mr. Erskine Smith and Mr. Dacus.
In terms of points to elaborate, I think we are observing the policy process in action. There's consensus that both people want action on this and that it's overdue as a policy priority. But I think we've heard from a range of stakeholders here today that it's not about the what, it's about the how. And it does very much sound like, across everything that we're talking about, this is actually the only intervention where we're actually talking about people, everyday people, not corporations and not large foreign corporations. So I'm supportive of further exploration as to the precise implementation of how we articulate that in legislation so that people are comfortable with it and that there's clarity, because I would not want to say, rush forward with something that won't be beneficial. But to some of our other questions, even related to the exploring these AMPs, in this conversation, it also assumes that we can even prove a competition case in Canada and actually find someone and find one of these companies. And back when we find Meta, then Facebook, which was brought up by Professor Quaid, again, to put that fine in context, it was less than an hour of Facebook's annual revenue for that year. So back to, now I'm pulling in a fines question, but thank you for the opportunity to slightly elaborate.
Okay. So for me, it's important to try and make this very relevant for everyday Canadians. And the proposed change to Clause 257 of the Competition Act creates a new criminal offence, which would prohibit employers from conspiring, agreeing, or arranging to fix, maintain, decrease, or control wages in terms of conditions of employment. So help me understand, would this clause have been helpful to have when the 3 of Canada's major grocery store chains all stopped pandemic wages on the same day?
I believe it would have been helpful, yes. I find it difficult personally to rationalize to anyone, but including myself, that there are instances where wage fixing works in favor of workers or consumers. And I think we've seen that franchisees have an interest in being able to intervene in the labor market, and that there's a stronger role for the state to play, whether that be through the Competition Act or, was earlier said, or if it's through labor law, looking at the province. This has also been something that there's increasing research and activism around, right? That Canada could take a more holistic, all-of-government approach to achieving the competition outcomes that we'd like to see. And there certainly does seem to be a stronger role for the provinces here.
And in your opinion, do you think the new provision, being a criminal offence as opposed to a civil matter, will act as a greater deterrent?
Yes, I think it could act as a greater deterrent. And I think primarily, though we're speaking, again, concurrently about the penalties, the AMPs, we fundamentally want the law to deter poor behavior. right? We want it to hopefully not happen in the first place before we're taking action and bringing cases forward.
That's a good point. So you've referred to corporate interests wanting to avoid significant changes to the Competition Act, including some of the ones outlined in the BIA. Why do you think those interests are mobilizing against these proposed amendments?
I think that we have a weak competition law. I've written about this extensively. I think it's difficult to bring a case forward. I think we win cases. We don't win them often. We have trouble bringing cases forward. And there's this huge disconnect. There's this huge disconnect between what people, everyday people, seem to expect. And I get these questions all the time, right? From the media, from people that want to learn, from policy colleagues. Hey, I see this case happening internationally, again, in a big tech context or digital. Are we taking it here? What happens here? What does it mean? And with so many of them, we can't even contemplate them under our current law. And that's why some of the research you previously heard about from Rob and Shabon when they testified, starting to take cases, right? Starting to take a data-driven approach and kind of back it into our law, I think could be something that we look at forward-looking when we're in a consultation. Because again, Canadians expect more, they want more on competition, and I think they talk about it all the time. They just don't use the words we're using in terms of competition law.
Merci beaucoup, Madame Lapointe. Merci.
Thank you, Ms. Lapointe. Mr. Millemia, you have 2.5 minutes. Thank you, Mr. Speaker. I'd like to go on to another topic, that is the public markets that go to the lowest bidder, public contracts. There could be a real impact on competition, especially for SMEs that couldn't compete. These projects may be cheaper, but could actually cost more in the long term because we would deprive ourselves of competitors. Is there a way we can ensure that we have quality projects and still have SMEs take part in public bidding? My question is for Ms. Bednar, but perhaps others would be interested in responding.
I'm happy to turn it to others as well. I'm sorry that I had to step away from my chair for a moment. The Competition Bureau has actually put out a few years ago, right, the guidance on people sort of self-selecting or self-declaring against bid rigging. There's research that I'll have to pull up, though I have papers all over around me on my desk related to it. And again, I think it's something that would happen outside of the Act, but is fundamentally like a pro-competitive outcome that signals the intention that we want to achieve and helps people kind of get there. So I think your question was, would something like that also benefit SMEs? And yes, I'm optimistic that it would, which is why I included it in the brief that Denise Hearn and I submitted, which is now available online. I believe you referenced. So if anyone wants to take a look, please do.
Merci.
Thank you. Would anyone else like to comment the principle of awarding public contracts? Government contracts, that is. If you'll allow, go ahead, please. I think this is a question that isn't encompassed by the current bill, but let me go back to what I said about the criminal offense provision for wage fixing. Currently, disbarment from public bidding means that any bidder would lose their capacity to bid in the federal public market and the Quebec public market as well. But this just goes back to what we've been saying. We need to study this more. Thank you, Mr. Mayor. Mr. Massey, you have 2.5 minutes.
Thank you, Mr. Chair. To Ms. Thiessen, with regards to the corporations that are abusing Canadian, industries, I'm worried about, like, we don't have a good history. In fact, actually, in the past, it used to be a business-related expense that you could actually write off part of an AMP or even legal fines and penalties. You got up to 50%. And so what I'm worried about is how does, and it was used as a loss leader, right? Whether it's, dumping oil down, the drain from the environment, not cleaning up shops properly or so forth, it stymies innovation in Canadian workforces and puts them at a disadvantage. What do you see out there with regards to that? I'm worried that if we don't have the proper systems in place, then, companies will take fines and penalties and so forth, as long as it makes good business sense if they can clear their edges.
Yeah, I think that's a very, very important point, and we need to make sure that any penalties that are in place deter the behavior that we are trying to prevent. If we don't have those penalties in place, we see things like exactly what happened in the grocery industry with that wage fixing and canceling pandemic pay, the examples that you've provided. And this goes to many different areas of Canadian law where A, the law needs to be improved, and B, enforcement of that law needs to be improved as well, because the law in itself is one of many steps that have to be taken. So we need to make sure that we are enforcing the law and trying the law and making sure that people are penalized and organizations are penalized when they interact and conduct that behavior.
And on the flip side of that, you do work with a lot of progressive employers that actually bring in workplace safety enhancements, other types of investments to make a better workforce for Canadian competitors. That if we undermine them, then we undermine the businesses that are actually putting the money towards that. They're also putting money back to the workers and doing all the things that struggle enough for health and safety and other things. But if other companies are doing worse, then doesn't it just put more people at risk and also disadvantages those that are more progressive?
Yeah, it absolutely does. It lowers the floor. It lowers the floor of competition for all sorts of organizations that are always trying to do the right thing in concert with their employees, with their unions, with environmental law. The list goes on. And if we allow this egregious behavior to happen, it makes it more difficult for the good actors to compete in a marketplace and actually elevate Canada's economy and society overall.
Thank you very much. We'll move to Madame Gray for five minutes.
Great. Thank you, Mr. Chair, and thank you to all the witnesses for being here today. You know, we've heard from some stakeholders their concerns that these comprehensive changes to the Competition Act need more consultation in order to ensure that they're doing what is intended. And so I've got a question here for, we'll circulate through the C.D. Howe Institute and then the Canadian Bar Association and then Mr. Wu. Do you believe there has been adequate consultation on these changes to the Competition Act as we are seeing in this budget? So we'll go first to the C.D. Howe Institute.
I don't think so. So again, I go back to the only public consultation I've really seen has been that run by Senator Whetstone, and you know the efforts of one senator should not make up the extent of us really delving into. And the efforts of a senator over maybe 6 months at most should not be the extent of our conversation on some very serious changes. I'm going to go back to some of the changes on wage fixing, where there are consultations that, for example, need to include provinces about their views on employee-employer relationships. That will be fundamental to the kinds of changes that can be very consequential for people's lives. So that's just one example of a group that you didn't see weighing in on the existing consultation that probably need to weigh in the future.
Thank you. Next to the Canadian Bar Association.
Sure. Thank you for that question. We would agree with the response of Mr. Dacus. Their consultation with respect to the specific provisions that are brought into this BIA was absolutely none. So we think it's very important that that consultation happen, not only at a higher level where there is a broad public consultation, as I think all the witnesses are in agreement of, that bringing in a variety of experts. We've heard people on witnesses on this here with us today speak about trade law, franchise law, employment law. There's been no consultation with the businesses themselves. And so not only do we see a need to consult on the broader issues, but the devil's in the details with much of this legislation. And so it's very important to also consult on the wording. As Ms. Bednar mentioned, it's also when you get into implementation, you need to ensure that we've looked at that quite closely.
Thank you, Mr. Wu.
Thank you for the question. So yeah, I would agree that the only consultation so far is under Weston's consultation process. And when you look at the submissions that were provided to that consultation, they are predominantly from observers and practitioners of competition law. So the range of views is coming from a fairly narrow set of stakeholders. And the larger, broader competition consultation that's supposed to come is intended to include a broader stakeholders, and I would hope that the amendments before us would enjoy the benefit of that broader consultation as well. And just briefly on the no poach wage fixing issue, when you look at the consultation paper by Professor Nakabuchi, his concern is that there is no financial consequence to potentially harmful wage fixing and no poaching conduct. So kind of he wants to he thinks there ought to be some mechanism in the competition law to provide that financial deterrence.
Okay.
But I would submit that deterrence is not only provided through a criminal provision. There are ways to amend Section 90.1 to strengthen it to also provide that deterrent effect as well, and that can be very much part of the consultation process.
Great, thank you very much. I've got only 1 minute left here, so I have one more question. Are you concerned there would be unintended or unforeseen consequences which could arise from these changes to the Competition Act not getting through a wholesome study? And I'll go to C.D. Howe Institute, and then we'll see if we've got time for a couple others, so if we could be brief. Thank you.
Oh yes, and we've only just scratched the surface of some of the changes here. We haven't even talked about questions of extraterritorial jurisdiction of a court order for the production of records as for merger reviews. Is that enforceable? So that's a whole other conversation that we have to have in terms of the implementation of some of these changes. So again, I ask about how implementable are these changes, and to have them come into force right away without really thinking them through is problematic.
I'm out of time.
Yes, we're unfortunately out of time, but I'll remind witnesses also that you can always submit in writing if you have additional information that you want the committee to be aware of. I will now turn to Mr. Dong for our last round of questions for 5 minutes.
Thank you very much, Chair. I too want to thank all the witnesses for coming today on short notice. I actually want to, go to Ms. Bettner, followed by Ms. Thiessen, and I wonder your comment on the consultation piece, because I would think that for anything to be in the BIA, the ministry would consult the industry and stakeholders before they make these suggestions. So I want to go to Ms. Bettner and Ms. Thiessen. What's your thoughts on whether or not enough consultation has been done, and what's the risk of not acting on these changes? Thank you.
Thanks for the question. Apologies, because I've got a Halls in my mouth. So, I think there's a broader kind of idealized version that many of us hold about how policy change can be achieved and the best fundamental practices. But the reality is we're so overdue for these changes, as I said in my opening remarks, that I think they should be welcomed. And I say that because many stakeholders, broadly, who over the past 2 years, as more people have been writing about competition, asking questions about how the Competition Act works, and really finding ways that it doesn't quite work as well as we think it could, have been met with arguments that say, actually, this Competition Act is perfectly up to the task. It's flexible. It can take on anything. It's ready to rock. It shouldn't have any changes at all. And these are now often in the public debate, the same voices that are saying, whoa, we need to really, again, tap the brakes and talk more. And we do need to talk more. So there's a public appetite. What would the risk be of not moving forward with these initial amendments? I think it's that we would be demonstrating, again, we're not taking competition change seriously. We're not ready to take these modest initial steps, on consumer privacy. That would put us in line with other actors internationally. This isn't coming out of left field. It's not coming out of nowhere in the broader competition conversation. Have we deeply consulted on it and ticked all our boxes in terms of pounding the pavement and previewing it for everyone? Not quite yet. But again, that's what I think people are anticipating and what we need to do. We're having 2 big conversations about competition right now, and they don't always go well together. One of those is mechanical. That's the kind of conversation we're having now, right? But the other is philosophical in terms of what the act is, what we expect of it, what Canadians expect of it. And that's a bigger and broader conversation. I'll give the rest of the time over to Kaylee.
Thanks, Vess, and thank you very much for the question. There has been some consultation on these, and the law has been tested and found that it was insufficient to study wage fixing. So that needs to be fixed, and it needs to be fixed now. Can we consult further after this change is made? I think that that's really important, and I'm looking forward to participating in the additional consultations that are going to happen over the next year. And the risk, I think, of not implementing this wage fixing change now is that it will languish for years. Just like changes to hours of work rules have languished for years in consultation, and should people get a break for lunch? When should they get a break for lunch? It means that we're having the same conversation over and over again about something we've already decided to change. We need to make this change now, and then we can discuss the rest of them further after. The risk of not making the change is that it doesn't happen.
Well, thank you very much for that input. And I want to ask both of you, your thoughts on the 3% of personal worldwide gross revenue as the changes to AMP. What's your personal thoughts on these?
Starting with, and thank you. Okay, sorry, Kaylee, I'm gonna jump in. I also want to say, in case I wasn't clear on this, like I'm not trained as a lawyer, so I'm happy to defer to others, right? Overall, but I think in terms of why we have AMPs, one, fundamentally as a deterrent, and two, so that people can be penalized, firms proportional to what's happening. And again, this is a novel design in terms of the 3%. I think we've heard, should it be of Canadian revenues versus internationally, worth ironing out. We could see an additional change or amendment through this future consultation, but I think it's important. I'd love to make a graph for you of our AMPs in Canada and benchmark them against our international peers, and then we can have another conversation about what our reputation means in that regard. But Kaylee, I'll turn it to you if you have something to add.
I don't have a specific idea of what the threshold should be. I definitely agree that they need to be much higher. I like the idea of them being proportional to the income or the profits that corporations have worldwide. And one thing that I've heard a few times today is that this change will damage Canada's reputation. And I think what we would actually see is other countries following suit. This conversation is happening globally. We need to make sure that we are deterring the behavior and that we're punishing this behavior when it happens. And if we moved, other countries would move as well. It's very, very important. Right now, we're being held hostage by this argument that, no corporation will ever invest in Canada again. I just don't think that that's true. And if we moved, others will as well.
Thank you very much. I would love to see that graph that Ms. Bettner talked about. So if you do come up with it, feel free to submit through written submission. Thank you. Chair.
Merci beaucoup, Monsieur Dong.
Thank you, Mr. Dong. Thank you to all our witnesses. This has been a very good panel, wonderful panel that we've had here, and thank you for being available so quickly. Colleagues, I'd like to remind you that by next Friday, I will be required to respond to the chair of the Standing Committee on Finance, and you will also have the chance to take a look at or submit your comments, amendments, and so on that you would like to provide it to the report. And don't forget to send them quickly because they need to be translated. Thank you to our clerk, our analysts, our interpreters, our technical team. This sitting is adjourned.